I am letting the law clerk in, starting the recording, letting I can know we can begin to broadcast. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 21-5120. Oceana Inc. Appellant versus Gina Raimondo in her official capacity as Secretary of Commerce et al. Ms. Treese for the appellant, Ms. Moring for the appellants.
Good morning. Counsel for appellant, you may begin.
Good morning, Your Honors. May it please the court, this appeal presents two distinct issues with respect to the service's management of the dusky shark, which has remained overfished for over 20 years as the sole result of bycatch. The first issue concerns the service's misinterpretation of the Magnuson-Stevens Act. The service violated Section 1853A15 of that act by exempting itself from the act's requirements and failing to establish any measures to actually hold bycatch of dusky sharks accountable to the limit the agency specified. The second concerns the service's unsupported conclusion that the measures it included in Amendment 5B will reduce dusky shark deaths enough to allow the population to recover. That conclusion was arbitrary and capricious because it relies on speculation rather than reasoned analysis and evidence. Turning to the first issue, I first want to clear up any confusion that might have resulted from the disconnect and what the issue that Oceana raised versus what the federal government addressed in its brief, which was whether the act allows it to specify an annual catch limit of 0. There's no actual dispute that it does allow an annual catch limit of 0. What the act does not allow is for the agency to set a catch limit of 0 and then chronically allow catch to exceed it because it has no accountability measures to hold catch to that limit.
Do you agree with the, it seems to me you do agree, I should put it that way, with the fisheries service that catch includes bycatch mortality?
Yes, sir.
Not all bycatch, it's just the mortality.
Yes, sir. It's the fish that die as a result of bycatch.
Okay, but that doesn't include all the ones that are caught.
That's right, Your Honor.
Yeah. Okay.
Yes. So the agency's misinterpretation here is embodied in an exception it created in its guidelines, which state that as long as the service sets the annual catch limit at 0 and prohibits intentional fishing for a species, it can escape establishing additional accountability measures that hold catch to that limit of 0, or in fact, to any numerical limit.
Can I ask you again, are we just dealing here with long line and not netting?
We are dealing with a number of fisheries here. We're dealing with at least pelagic and bottom long lines, as well as, I believe, gillnet fisheries, as well as recreational fisheries. So it's a wide range of gear.
How can you catch a 400-pound dusky shark in a gillnet?
Those gill nets can be very large and very strong, Your Honor. There are nets that actually catch whales.
Yeah, but the long lines, although it's not specified, and I'll let you get on with your argument. I just want to be clear about this. The long lines are actually they're fishing for swordfish and tuna. Is that what it is?
Yes, sir. Those are the main target species.
Yeah. Okay. Thanks.
Certainly. Now, the service's interpretation essentially eviscerates the meaning of Section 1853A of the Act, which is clear under Chevron Step 1, as shown by the text and the context and the history of that provision. And I'll walk through each of these, starting with the text. Now, Section 1853A15 requires the agency to establish a mechanism for specifying annual catch limits at a level such that overfishing does not occur, including measures to ensure accountability. So starting at the beginning, it requires a mechanism that essentially has two halves, the annual catch limits and the accountability measures. The first half, the annual catch limits, has each of these terms has a plain meaning that the service agrees with. As Your Honor was asking about, the service agrees that catch includes bycatch mortality, and also agrees that the ordinary meaning of limit is a bound not to be passed. So, and then that phrase is modified by the phrase at a level such that overfishing does not occur. So in other words, the annual catch limit must put a definite bound on bycatch that occurs annually, and that number has to be low enough to ensure that overfishing doesn't happen. The second half.
What do you do with the agency's response that the statute doesn't bar what is done here, and it's, in its view, these will reduce the mortality, and this is the first stage, all right? And then if it's not low enough, they can modify what's required.
Well, Your Honor, I think that violates the plain language of the acts, because
the agency's argument is the plain language leaves it a lot of discretion. The Congress didn't bar things, it didn't define things. It said the agency is to carry out the statute. And so, in the agency's view, what it did does not contradict any limitation in the statute itself, whereas your argument is no, it has to be able to say definitively that if we do this, then the catch will reduce by 35%.
Yes, Your Honor, these are separate issues.
I know you want to define them that way, but the Secretary's view is broad discretion. Had Congress wanted to define things the way you say the agency must interpret the statute, it could have done so, but it didn't.
Well, the agency is glossing over a lot of statutory context, as well as the plain text and the history of this provision and taking that position.
Well, what's the plain text that bars the limit at not over zero? And what's the plain text that says if you can't determine specifically that what you're doing is going to reduce it by 35%, so long as you're on the road to that and you see what this does, and then you come back, and if it's not enough, then you do more.
Well, the plain text requires the agency to specify a limit. So here
it says
they've specified. Pardon me.
It requires them to establish a mechanism for such a limit. What about that language?
Yeah, so the establishing the mechanism, again, here it's envisioning a coherent system where in practical terms, usually what a fishery management plan would do would have, for example, a formula or some mechanism for specifying that actual number year after year. And so that's, I think, part of where the mechanism comes in. The mechanism also includes these measures to ensure accountability. I think where we part ways with the service, or one of the ways, is what that accountability means.
And where did Congress define it in a manner that bars the agency from interpreting as it did? Isn't that your burden?
Yes, Your Honor. And if you look at the context of the act and read this provision as part of the overall section 1853A, that section begins with 1853A1A that requires all fishery management plans to contain measures necessary and appropriate to prevent overfishing. So
I guess the agency's response would be yes. And it's getting there. It may not get there the first year, the second year, but maybe the third year, et cetera. It has to see. What happened?
That's not what the statute requires the agency under 1854E to end overfishing immediately.
No,
not
it
just
doesn't. That's my point. And that's the agency's point. Where does it says immediately?
That is in 1854E7, I believe, that the agency has to, in its rebuilding plan, end overfishing immediately. And Congress actually, in the legislative history, looked at instances exactly like the dusky shark. It looked at the fact that the act had required the service to end overfishing for decades, and had failed to get there, and that overfishing of overfished fish species, much like the dusky shark, remained a significant problem. And in statements, including in Senate Report number 109-229 at 21 and 23 to 24, for example, and also at 7, Congress emphasized that failure to end overfishing was resulting from a failure to require catch to adhere to limits year after year.
Right, but that's really my point. What the legislative history shows is they tried over decades to do it. It didn't work. What you're arguing, as I understand, is therefore we must read this statute to say you have to do it within a year. Or you have to do it within a specified time limit.
Well, Your Honor, we're not concerned so much with the time limit here as with the overall compliance. What the agency has proposed to do here is always allow catch to be higher than the limit it's set by some completely unspecified number. So it has basically set up a system where it's always violating the catch limit year after year after year.
The bycatch limit for mortality anyway is 0. What happens if the one ship pulls in a dead shark? What is the consequence of exceeding the 0 limit?
Under the approach the agency has adopted here, there's no consequence whatsoever. There's no consequence if they pull in 500 dead sharks. Yeah.
So I'm wondering,
that's the exact problem here.
I'm wondering if your problem is not with the number 0, but with the enforcement of it.
Yes, sir. That is exactly the problem here.
Right.
That is, yes. The problem is that the statute contemplates, specifically because this more general approach had not worked for so long, that annual catch limits and accountability measures would be added as a specific mechanism to finally require the service to use the specific mechanism to finally end overfishing.
Yeah.
Ms. Grace, what about section 1853A11? That says that the service has to reduce bycatch to the extent practicable, right? And bycatch kind of by its nature is something that's accidental and not intentional. So, I mean, it seems then that Congress has given the agency a fair amount of discretion as to, how they reduce bycatch in a way that is practicable.
Well, Your Honor, that section provides for a broader requirement to reduce bycatch across the board as a matter of reducing waste, and notably, it applies to species other than fish as well. It applies in all instances. What Congress was trying to get at with 1853-18 was setting a very specific limit on that bycatch low enough to end overfishing and sticking to that limit, ensuring that catch didn't chronically exceed it. So what A15 does is add specificity and add an additional mechanism. And it's basically another additional requirement.
They
that
have,
also-
the service has taken some steps to reduce not so much bycatch, but mortality. The requirement of circle hooks, number one, which prevents a gut hook, which will kill the fish usually. And then also making the circle hooks non-stainless steel, which is important because you know, if the fish escapes with a hook in its mouth, it's going to rust away. What else has it done to prevent mortality?
Well, Your Honor, with respect to that circle hook requirement, notably the study the service relies on there actually states that requiring circle hooks, at least in the bottom longline fishery, does not have any effect on reducing mortality because they use a larger J hook, as we discuss in our briefs. They have over the years.
There must be studies going the other way. I mean, circle hooks are becoming fairly common in recreational fishing now because of the catch and release requirements, and it's much easier with a circle hook than with a J hook, which may get caught on the interior of the fish.
The service hasn't cited any other studies that go the other way. The issue that the study found that the service cited was that in the bottom longline fishery specifically, they use a larger J-shaped hook that the sharks apparently don't swallow, so they don't get gut hooked with that hook. So they in that study, they didn't find any difference between using the J hook and the circle hook, even though there are ancillary benefits to other species to using circle hooks.
Okay, thanks.
Thanks. I'm conscious that I'm over time right now and would like to reserve time for rebuttal unless the court has more questions.
All right, thank you. We'll hear from counsel for appellee.
Good morning, and may it please the court. I'm Ariel Moran on behalf of federal appellees. This court should affirm the district court's judgment. The service has been working since the 90s to conserve the dusky shark, in addition to closing the dusky shark fishery, slashing commercial shark quotas.
Pardon me, I'm having trouble hearing you. There's an echo, I think, that's going on. There's some adjustment you can make.
We tried to adjust this before. Let me see if I can connect to my phone. That might be a little bit better.
I don't think your time should be running while you're doing that. Yeah, go ahead. Have you tried something?
We were experimenting with this before we got into this room and thought we had solved the problem, but let me see if I can connect to a different audio source. One second.
Have you done something? Now we can't hear you at all. I'm sorry.
Well, she appears to be working on it. She isn't saying anything. And do you know if anybody's helping her?
I am helping her, Judge. I am calling her. Hello? Maureen, you should now be connected via your phone, but you need to disconnect your computer audio. Please go to the lower left-hand corner of your screen to the mute button and on the arrow pointing up.
Yep, and I clicked the LG Full HD.
Okay, so maybe you can talk more loudly.
Great. Can everybody hear me now?
That's much better, much better.
Okay,
Yeah.
wonderful. We're connected through my phone.
Okay.
All right, counsel for appellees, please begin.
As I was saying, the service has been working since the 90s to conserve the dusky shark. In addition to closing the dusky shark fishery, slashing shark quotas and retention limits, and numerous other measures, the service has now instituted 6 new accountability measures through Amendment 5B. This case fundamentally comes down, as became clear during Oceana's presentation, to their disagreement with the service's scientific judgment regarding the best accountability measures to end dusky shark overfishing. So I'd like to start by clarifying the remaining dispute. As Oceana just clarified, it does not argue that the Magnuson Act precludes the service from setting a limit of 0. Rather, it argues that the limit that the service set here is somehow not a limit because Oceana does not believe that the accountability measures that the service chose strictly enforce that limit. What this argument comes down to is a dispute about the appropriateness of the service's chosen accountability measures, fundamentally not really any issue of statutory interpretation. Oceana's first argument simply collapses into its second. Oceana wanted different accountability measures and argues that it was unreasonable for the service to fail to enact its preferred measures, but it cannot show that the measures chosen were arbitrary and capricious. Before I turn to that sole remaining argument, I want to address briefly Oceana's attempt to reframe its objection to the accountability measures as a statutory interpretation issue. It's clear that Amendment 5B in no way violates the Magnuson Act. The service complied with its plain requirements. It established a mechanism for an annual catch limit and set that annual catch limit at 0, and that annual catch limit accounts for bycatch mortality.
Well, let me ask you, as I understand their argument, it's that why did Congress pass this statute? For decades, the agency had been trying to do this. It hadn't succeeded. So now the statute says establish a mechanism that reduces the mortality. And you need to do it by 35%. And what you've done, you may not have adopted what we want by accountability measures, but what you've done isn't enough. And as I understand it, the agency acknowledges that what it's done may not achieve the 35% reduction. So what is your response?
The service concluded that the 6 new accountability measures give a 50% chance of rebuilding
50%,
the stock.
that's not the same.
That's correct. We have a 50% chance. So the chance is not 100, nor could any accountability measure ever obtain a 100% chance.
Maybe not, but 50 or 60 is pretty low, given that you're trying to get up to 100.
That is true. The service decided that a 50% chance was sufficient here in light of a couple of things. First of all, massive data variability. In this case, it is very difficult to get information about absolute abundance of dusky sharks. It's also very difficult to get any data about bycatch mortality for dusky sharks. Interactions are incredibly rare. So there isn't much data on this issue. In addition, the most recent stock assessment, which was undertaken through process in 2016, showed 5 different options for ending overfishing. Now, we have additional data from various ESA petitions that had been instituted that show that it is likely that the dusky shark population is actually more abundant than the 2016 information gave, which led the service to conclude that a 50% probability of rebuilding the stock was sufficient.
Is the low stock just on the East Coast? I mean, as I understand it, this shark is also found in the Pacific Ocean.
The sharks are found for these management purposes in a number of areas, but largely on the East Coast. It's found near Japan, near also the in some areas in the Pacific, but not for management purposes.
Okay.
So in order to make that move, right? So the measures that have taken place so far have created, in the most recent stock assessment, we have seen an order of magnitude lower fishing mortality than in 1999 when the service began management. Overfishing has reduced 87% since 1999. In 1999, we saw overfishing hovering around 9 times the sustainable level. It dropped to 1.59 in 2011 and 1.18 in 2016. So I think that that puts in context what the service is trying to do here. It's trying to make that small move from 1.18 times the sustainable level down to 1. That's the overfishing limit. The service implemented 6 new accountability measures in Amendment 5B to make that shift from 1.18 down to 1. And the service concluded that those measures give it a 50% chance of rebuilding the stock, but a 77% chance of immediately ending overfishing. Those accountability measures include requiring recreational shark fishers to complete an online training course, which will increase their ability to identify dusky sharks and release them with a minimum of harm. There's substantial research supporting this measure. Research on other United States Atlantic prohibited species, such as the thorny skates, have demonstrated that a focused outreach and species identification training can improve compliance rates with prohibited species regulations over 98%, including reducing illegal landings by 95%. Additionally,
let me understand this a little better. You do, or the agency does receive information that on fishing expedition out of X harbor from June through August resulted in, let's say, 500 deaths. And either the fishermen or the oversight agency run by the fishermen are supposed to report deaths, correct? So if the agency is having difficulty getting the information, why can't the agency tighten up its reporting requirements?
There's no way to tighten up the reporting requirements for a number of reasons. First of all, misidentification. Dusky sharks are relatively difficult to identify and look like a lot of other ridgeback sharks. So we're not getting.
Oh, the fisherman's not going to know what he or she caught?
Well, many of the regulations prohibit bringing the sharks onto the deck. So we're talking about sharks that are in the water. They know that they have to release almost all ridgeback sharks because they're prohibited species. So the fishermen are trying to de-hook these shark species and often are not making attempts to identify them, or if they are making attempts,
without pulling the fish out of the water. So all you're seeing is the snout, mostly. Yeah.
Right, exactly. Because bringing the fish onto the deck increases mortality substantially. We've prohibited that, but that means that trying to identify dusky sharks is incredibly difficult. We're not getting very good data on identification or mortalities for dusky sharks. The service also realized that there is a potential problem for either under or over reporting. It's possible that fishermen want fewer regulations and so are either underreporting dusky shark mortalities or want it to look like dusky shark abundance is increasing, which would lead them to overreport dusky shark mortalities. We simply don't have good data. In addition, dusky shark interactions are pretty rare as it goes. So we're not seeing a lot of interactions with dusky sharks, which is also
the fisheries service has inspectors on some boats, doesn't it?
The fisheries service does have observers on a certain number of boats, but for obvious reasons cannot have 100% observer coverage on every fishing trip that is taken.
Is there anything in the record to indicate what percentage of fishing boats they have inspectors on?
There is some information in the record. It depends on any given year. It depends on the fishery. It can be something like 10% of fishing trips that have an observer on, depending on the particular fishery.
Okay.
And the observer coverage isn't excellent and doesn't account for everything. But fundamentally, what matters is that the service did conclude that there's a 50% likelihood of rebuilding stock and a 77% likelihood of ending overfishing. And the measures that it's taken, in addition to being supported by data, also have, frankly, intuitive appeal. They're very easy to explain because it's clear that they will end overfishing. The first, as I was explaining, is supported not only by the Curtis and Sotheby 2016 study, which shows a reduction in illegal landings by 95%, but also the Poisson 2016 study indicating that safe handling and release increases post-release mortality rates. The service also considered the unique identification difficulties that Oceana raises. The service considered those difficulties and designed the training specifically on identifying ridgeback sharks. As I mentioned, almost all ridgeback sharks are prohibited species. And so although there are difficulties in identifying dusky sharks particularly as opposed to other ridgeback sharks, the training doesn't need.
Are all the ridgeback sharks migratory?
I don't know if all ridgeback sharks are migratory, unfortunately.
Okay.
So the training has to focus on identifying ridgeback sharks as opposed to identifying dusky sharks in particular. So fishers don't need to identify the difference between a dusky shark and a silky shark, or the difference between a dusky shark and other prohibited ridgeback sharks. Ridgeback sharks have more readily identifiable features, specifically the ridge between two interdorsal fins that make them readily identifiable. Then when we go to the second measure, this required recreational shark fishers to use these non-offset, non-stainless steel circle hooks, which reduces mortality of released dusky sharks. We know that circle hooks are up to 66% less likely to lodge in the throat or the gut of a dusky shark than J hooks. The Wiley study evaluated the use of circle hooks in recreational fisheries and found that circle hooks should reduce the mortality rate of hooked dusky sharks by 63%. While Oceana contends that the service did not specifically add up the number of mortality reductions.
The circle hooks, the circle hooks are required not only for recreational, but also on the long line, right?
Yes, that is correct, on the bottom long line.
Which increases the cost for the fishermen, right? Because the hooks will rust.
That is true. The service has an obligation to end overfishing, and those conservation measures sometimes increase costs. All of that is considered in the environmental impact statement.
Yeah, okay.
Now, I think I'd like to turn to compiling a bit of this data. Oceana contends that we cannot reach this 35% mark, but we don't need to specifically add every measure up to reach 35%, because it's clear that the measures in totality will reach 35%. For example, we know that recreational fishers cause a majority of dusky shark interactions and bycatch mortality. The best data we have show that bycatch mortality in the hundreds in the recreational fishery versus tens in the commercial fisheries. That's an order of magnitude difference in that data. So let's say for a conservative estimate that 55% of bycatch mortality is caused in the recreational fishery. There's two measures that the service has instituted in that fishery. First, the circle hooks, which are expected to reduce bycatch mortality by 63%. And second of all, the training measures, which should reduce landings by 95%. Even if you just take 63% of a 55%, you get to 35%, which is the total reduction in mortality that the service needs. Of course, this assumes that bycatch mortality comes from the released sharks and not from misidentification of landed sharks. But in that case, the training measures should reduce landings by 95%. Of course, 95% of 55% lands you at 52%, which overshoots the 35% mark. But it cannot be true, as Oceana contends, that each measure must have a substantial effect, even if any individual measure were not getting to the
for recreational. I mean, I understand from what I've read that these sharks move into shallower water And so it would be surf fishing, for example, would be one of the recreational methods of catching them. But do you have to get a federal fishing license? I thought that was all regulated by the state. Surf fishing.
I'm sorry, do you need a federal fishing license for what exactly?
Suppose I go out with a surf rod and I'm fishing for something else, but with a baited circle hook. If do I need a federal license to go out and do that because I might catch a dusky shark?
If you're in federal waters and you want so
I thought that was all regulated by the state. That's why I'm wondering.
There's also state regulations. So the Fisheries Service works in conjunction with states, and it depends on the waters that you're in.
Yeah.
One thing I'd like to address, because it came up earlier, was the enforcement mechanism. It isn't true that there is no enforcement mechanism here. Fishermen face penalties under the Act for noncompliance with the protocols, C50 CFR 635.21, C6I, and also 635.71. Our enforcement works with the U.S. Coast Guard, works with different state enforcement agencies to enforce the regulations, and you can find that penalty schedule for HMS penalties.
So how's that work? You have a boat where there's no observer on it, and it pulls in and has its catch. Is it required that the captain report the mortality of sharks in that fishing voyage, and then gets fined for it? It sounds like a Fifth Amendment violation. I don't know.
The way that this usually works is that the sharks will be brought into port, and there's a variety of state enforcement agencies and also Coast Guard. And so it isn't that 100% of dusky shark mortalities will be caught by some enforcement regime, but there is an enforcement regime, and there is an ability to institute civil penalties.
Yeah. Another question. This is that I couldn't figure out. These long lines are sometimes in the water for as much as 8 hours. Is that right? And
yeah.
And if a fish gets hooked in when it first goes down, the chances are that fish is going to die by being in the hooked there for 8 hours. What do they do? What do the fishermen do when they bring that line in and they've got all these dead fish on it? Do they just throw them back into the ocean? They don't try to process them for human consumption, do they?
I don't know how all of the fish species are handled. I just know for dusky sharks, they have to be dehooked and thrown back into the water, either whether they're alive or dead, in order to prevent incentives for catching dusky sharks.
It would seem to me that there's an incentive to get the long line out of the water as quickly as possible, because otherwise you're going to lose a large amount of the catch. So,
well, I think that not all fish, of course, are hooked at the very beginning of that time, and so the soak times, as opposed to the hook times, are an important thing to remember, that there's a difference between, especially with regard to dusky shark bycatch.
Okay, thank you.
If there are no further questions, then we would rest on our briefs and ask the court to affirm.
And thank you, counsel. Counsel for appellant.
Thank you, Your Honors. I first want to clarify that there are two very distinct issues, and the measures we're talking about are different in each. The first issue is that there are no accountability measures that hold catch to zero, and the agency admits that catch will always be above zero. And there is not, there may be enforcement for an individual fisherman catching a shark, or failing to follow a protocol, but there is no measure to react to excessive catch above the catch limit, whether that's by 5 sharks or 500. Now, the rebuilding measures in Amendment 5B like the circle hook requirement, are separate. They are not accountability measures. They're not ensuring accountability to zero or any other number. And there are, I think, I also want to clarify, switching over to those rebuilding measures, I want to clarify a couple of things in response to what counsel said. The agency admits at multiple places in the record that it cannot estimate how much overall mortality any of these measures, overall mortality reduction, any of these measures will result in. For example, at JA 593, 599 to 600, 606. So the rates that the Services Council is talking about are rates that apply to studies on different species, and the service doesn't even know what the overall number of dusky sharks is, how many are caught in the recreational fishery, how many are caught versus how many are caught in the pelagic longline fishery. So they have no idea what that overall mortality reduction would be from applying that rate of mortality reduction. And I also just want to note that the service also stated itself that all of these measures have to work in order to get that to that 35%. I mean, at several places, the service talks about how collectively these measures will add up to a reduction, or cumulatively they will work to reduce mortality by 35%. For example, at JA 593 and 698. So if one or two of those measures doesn't work up to their assumptions, and their assumptions are based on some pretty thin evidence, the whole package is likely to fail. And as was discussed earlier, that whole package with absolutely full success only has a 50% chance of rebuilding the species. I mean, if everything goes right here, there's only a 50-50 chance that this species will finally rebuild by the next century.
I guess what troubles me in part about your argument is intellectually you may be correct, but practically, how do you enforce an absolute limit given the nature of the industry, the nature of the fish, the difficulties in getting data, etc.?
Well, Your Honor, the notion of practicability is one that Congress specifically considered when it was going back to the meaning of 1853A15 and the enforceability of catch limits specifically.
That's my point, basically. That's what my next point was going to be. That is that, Congress understood this.
Yes, Your Honor, but Congress, in both the statutory context, we see that Congress included the notion of practicability in other provisions, including in 1853 A13 and A11, but specifically left it out here. Now, in order to buy the government's reading, the provision would have to read something like, establish a mechanism to specify annual catch limits and measures to ensure accountability to the extent practicable. But it left that phrase out here, and we have to assume that it did so intentionally. Now, if we look back at the legislative history, you'll see that Congress specifically heard concerns about uncertain data and reporting on the ability of the agency to set catch limits and accountability measures, and responded, in fact, that instead of inserting the practicability, it expected that having to set these annual catch limits and managing to those limits would result in better reporting and data collection. And that statement is at Senate Report number 109-229 at 24, for example.
I don't doubt that that's in there. And you acknowledge that for the agency's system to work, everything has to add up. Well, the agency can find out if things add up, and if they don't, make adjustments. But what I don't understand at this point is there's no accusation that the agency acted in bad faith, that it had data directly contradicting the conclusions it reached.
Well, it did have, at least with respect to the circle hook requirement in the bottom long line fishery, the study it relies on specifically did find that they looked at the effects of using circle hooks versus the larger J hooks that the bottom long line fishery uses, and found no difference in mortality. So that study does contradict their finding. And with respect to the agency being able to try things out, the agency was obligated at the time it promulgated Amendment 5B to find that it was reasonably likely that this would be successful in rebuilding this species. And so it had to determine at that time that these measures were supported by evidence and are reasonably likely to work.
Reasonably likely to work based on the evidence and their problems with the evidence. That's what I don't understand about your argument.
Well, Your Honor, there's no question that deference is due to the agency when it applies evidence and makes a decision consistent with it. I think
but if it doesn't have that evidence, and there's a reason why, first of all, you can't pull the shark out of the water, so they're difficult to identify, all kinds of things. So I appreciate your argument, but I don't see Congress mandating what you are saying is mandated in the manner you say it is mandated. That's all I'm trying to understand.
Well, I think with respect to the rebuilding measures, the agency did have data on a couple of measures that it rejected. So they were not entirely without data. For example, they did have data showing that prohibiting the use of pelagic longline gear in certain areas with very high dusky shark bycatch could reduce bycatch mortality in that fishery by 28%. Now, the agency chose not to use that measure, but they had that data directly relevant to that fishery and directly relevant to dusky sharks. So they weren't without any sort of direct science to use. They chose
but it decided to go another way.
Yes, Your Honor. And even then, however, they still, in absence of data, they have to make some reasonable showing that the measures will be successful in order to meet the mandates of the act in terms of rebuilding and reducing mortality. They can't simply fall back on saying that it's just their expertise that.
Well, in their best judgment, evaluating what's out there, etc. That's all I'm trying to understand.
Yes, Your Honor. I think there's simply a lot of assumptions based on absence of data made here that the agency's own track record has shown isn't working. And they actually have quite a long ways to go here. I mean, they have to reduce mortality by more than a third. It's not just a small task ahead of them that can be solved by nibbling at the edges. Now, I think, again, with respect to the annual catch limit, that is a separate issue, and I think it's very important that to give effect to Congress's intent here, that Congress did not intend to allow the agency to set one number as its limit and then allow it to completely be violated. I mean, that that eviscerates the ordinary meaning of the term limit, and certainly reads any accountability out of the act, because a limit that's routinely surpassed without any consequence is simply not a limit in any real world sense. And I'm conscious that I'm over time, but I want to make sure that that I'm answering all of the court's questions here.
Any further questions?
Not
Thank
by
you.
me.
Thank you. We'll take the case under advisement.
Case number 21-1100 et al. The Nasdaq Stock Market LLC et al. Petitioners versus Securities and Exchange Commission. Mr. Hungar for the petitioners, Mr. Frida for the respondent. Case number 21-1100 et al. The Nasdaq Stock Market LLC et al. Petitioners versus Securities and Exchange Commission. Mr. Hungar for the petitioners, Mr. Frida for the respondent.
Counsel for petitioners, you may begin.
Thank you, Your Honor, and may it please the court. The Commission admits that the goal of its market data infrastructure rule was to reduce information asymmetries based on the perceived problem of a two-tier data market in which market participants who are willing to pay more receive more data faster than others. But the Commission's own findings establish that the rule will actually exacerbate the problem it set out to address. That is classic arbitrary and capricious decision-making. If the Commission's costly new regulatory regime operates as it's intended to, instead of a so-called two-tiered data market, the Commission will actually have made things worse by producing a multi-tiered market in which, as it concedes at pages 186, 221, and 241 of the Joint Appendix, different market participants will receive data at different speeds with different content and different reliability, all depending on how sophisticated they are and on how much they're willing to pay. Precisely the supposed problem that the Commission said it was addressing. In fact, by codifying the privileged category of self-aggregators who have an inherent latency advantage over all other market participants, and by precluding anyone except broker-dealers and investment advisors from enjoying that specially favored status, the Commission has actually formalized two tiers of data recipients, and it expects the competing consolidators to create additional tiers through their varied product offerings with varied pricing, content, and latency. And the Commission has made things still worse again by relaxing the regulatory requirements for data reliability in the current regime and discarding the heavily regulated single processor system. And as the Commission recognized at page 241 of the Joint Appendix, some competing consolidators will offer less reliable data services than others, meaning that price-sensitive market participants, the ones most likely to hire the less expensive and less reliable consolidators, will face consolidator-specific data outages to a greater extent than their better-heeled competitors who can afford to hire more reliable consolidators, meaning that there's now going to be a whole new category of information asymmetries created by the rule that doesn't exist in the current system, where everyone can rely on the heavily regulated and reliable securities information processors that provide data to the entire market. For all these reasons, the rule is arbitrary and capricious and should be vacated.
Mr. Hungar, your briefing uses the language of expropriation of proprietary market data, but you're not here making a constitutional claim.
Correct.
Are you?
That's correct.
You did make such a claim before the agency.
I believe such a claim was made before the agency, but that's not part of our submission today. We're relying here on the Administrative Procedure Act arguments that we are advancing. I mean, one, obviously, under the Administrative Procedure Act and the Exchange Act, that expropriation and its impact on competition is one of the key elements of our arguments about why what the commission has done here is arbitrary and capricious. And unless the court has questions about the first point about the dramatic disconnect between what the fundamental problem the agency said it was addressing and the fact that its alleged solution actually makes the problem worse, which in and of itself is fatal to the rule, I can turn to the economic aspects, which are a separate and independent reason for invalidating the rule. Because the commission...
Well, why isn't the agency or the commission entitled, as it were, not to want a system where two groups control, or even one group controls, and an open competition system, understanding that competition can be messy and it's not as neat and clean as having a couple of monopolists run the show. But in its judgment, there are other considerations that in the agency's opinion warrant a more competitive system than now exists, even where one of the two favored groups' profitability may be somewhat adversely affected until the new market adjusts and we see where everyone comes out.
Your Honor, the problem here is not competition. In fact, in the existing regime, the exchanges compete vigorously with each other in the proprietary data markets, as the Commission concedes at page 227 of the Joint Appendix, and the Commission's regime is eliminating that competition by imposing its centralized price controls regime on that formerly competitive market. The problem isn't that the Commission says it's bringing competition. The problem is its rationale for the regime that it has set up is directly contradicted by its own findings about how that regime is going to work. Again, the fundamental premise of this rule, the fundamental justification for it, is that the Commission says there's a problem. And what is that problem? According to the Commission, it says this even in its brief at pages 3 and 19, the problem is information asymmetries. That is, according to the Commission, and this is from page 219 of the Joint Appendix, the problem is the two-tiered market in which market participants who pay more get more data faster. But the solution that they have proffered for that perceived problem doesn't fix the problem, it doesn't ameliorate the problem, it makes it worse. And that is arbitrary and capricious. And again, we're relying on the Commission's own predictions and findings about how it's going to operate, which means it's going to increase latency variation, increase content variations. And again, the self-aggregators in this new regime, the Commission is codifying for the first time a special category of market players who have a privilege that no one else is entitled to, which is this privilege of receiving this data themselves as market aggregators and acting immediately on it while everybody else is waiting for the competing consolidators to aggregate and then distribute. This is a new codified version of the two-tiered market that the Commission says it's trying to get rid of. And then the point I made before about reliability, the fact that the Commission is now admitting that it's going to create a system in which reliability varies from one provider to another, meaning that for the most price-sensitive participants, they're actually going to be at risk of suffering asymmetric data outages, a risk that does not exist in the current regime. So in all these ways, they've made the problem they claim to be trying to fix worse. That is arbitrary and capricious. Maybe they could have justified, we don't think so, but they could certainly have tried to justify the rule in a different way. And then there might well be other fatal flaws, but the one we've identified here would not be at issue. But when an agency says, we're trying to fix problem X, and here's our solution to fix problem X, and they make problem X worse, that is arbitrary and capricious, regardless of what.
Worse from whose perspective? That's part of what the Commission is getting at.
Well, with respect, Your Honor, they admit that there could be reduced latency, or rather increased latency, that is slower data and less content. The competing consolidators don't have to provide all the data to everyone. Indeed, the commission expects that they won't. And they don't have to provide it all at the fastest possible speeds. Indeed, the commission expects that they won't. And they're going to compete based on price and reliability and all these other factors. So the commission's own findings contemplate a multi-tiered market, which is inconsistent with their claim of reducing information asymmetries, which again was the alleged purpose and goal of this rule.
I want to try to understand the mechanics here, and I'm not sure that I really have a handle on it. The consolidators are, is this correct, the New York Stock Exchange and Nasdaq?
At present, there are two securities information processors, one of which, and they are affiliated respectively with those two entities. Yes.
Yeah. Okay. And the idea is that maybe some other entities will enter into that, be able to enter into that market. How would that work? I mean, the information would still be coming from just the New York Stock Exchange and Nasdaq, right?
Well, no. So there are approximately 16, I think, exchanges, more or less, plus a number of dark venues that are not exchanges in the traditional sense. They don't reveal their quotation data. That's why they're called dark venues. But so I think there are maybe 40 or anyway, there are many trading venues that exist. And all of that information is consolidated currently by the securities information processors.
Okay. And so it's not just the two exchanges, information from the two exchanges, it's information from all, however many there are, and there are a dozen more, right?
Correct.
Okay.
That's correct.
And now the self-aggregators, where do they come in? Would they be consolidators that only use the information for their own particular purposes rather than selling it to somebody else? Is that the difference?
Correct. They'll be again, only broker dealers or investment advisors, the entities that have been trying to obtain reductions in proprietary data fees. Only they would be able to qualify as self-aggregators, and they can receive this price-fixed data directly from the exchanges in this new regime and do whatever they want with it, while everyone else is waiting for the competing consolidators to aggregate and distribute the data.
That raises a question that I really don't know the answer to. Why aren't they doing that now? Why aren't the broker-dealers doing that now?
Well, some
current regime.
Some broker dealers do that now because, again, proprietary, in addition to the securities information processors that provide the consolidated feed, there's a very competitive market among all the exchanges that choose to participate in it, which is not just Nasdaq and NYSE, but others as well, that sell proprietary data in addition to the consolidated feed. And so entities that want to do that can do that now. In fact, anyone can. I mean, if you want to, you can go buy that data yourself. It's about $15 a month.
That was my next question. The day traders, for example, they must subscribe to instantaneous quotations, otherwise they couldn't operate.
Exactly. So in the current, because again, the market for proprietary data, separate and apart from the consolidated feed, is already competitive, as the commission admits. So you can go to NYSE or Nasdaq or SIBO and as a private individual day trader and say, I want to buy the full depth of book data, all this data that the commission is talking about directly from the exchange, and you can do it. And as I say, I think for Nasdaq, my client, I think it's $15 a month for an individual private trader. So it's not like it's confiscatory or expensive for somebody who's actually engaged in that sort of practice in the current regime.
$15 a month?
Wow. Yes, that's my understanding.
Mr. Hungar, what about, the SEC's position is that there won't be any latency differentials between the consolidated competitors and the self-aggregators. I mean, what is your view of that?
Well, I don't think that's actually, they say that in their brief, but I don't think that's actually their position because they concede in their order, I believe it's at page 374 of the joint appendix, but it's cited in our brief, that in fact, there may well be a latency advantage for the self-aggregators. And simply as a matter of physics, it has to be true because the competing consolidators and the self-aggregators will receive the data at the same time. They will then process it in whatever way they choose. And then the competing consolidators will have to transfer that data to their customers while the self-aggregators are trading on it. And all you have to be is ahead of your competitors. And if you're in this world, which again is a very small world of the most sophisticated traders that are trading on computer algorithms where microseconds, millionths of a second make a difference, right? It's not the day traders. It's indiscernible to you and me and to an individual who's trading based on what they see with their own eyes, because 100 microseconds, 1,000 microseconds, 100,000 microseconds is indistinguishable to us, but to a computer it matters. And so for those people, the difference between being able to trade while the competing consolidator is sending its data to somebody else before they can trade means they're going to get there first and they're going to get the trade. So, I mean, the commission is right to concede in its order that the self-aggregators may well have a latency advantage, and it's clearly going to be the case.
Mr. Hunger, a lot of, I'm just wondering, kind of on the ground, what's been happening since the rule has gone into place. I mean, and maybe this is something Mr. Frieda can speak to as well, but a lot of this comes down to, did the SECs properly predict what would happen with competition? And I'm wondering if you have any thoughts about what actually has been materializing in the period. I know it's being phased in, the rule, but I'm just wondering if there's any sort of on the ground observations.
Not that I'm aware of. And remember the rule, the phase in, there is a phase in, but we haven't gotten to the point yet where anybody's even decided whether they're going to enter the purported competing consolidator market. So there's not really any evidence at this point. I haven't, I see my time is running low, but I haven't had a chance to talk about the second important element of our claim, which is the violation of sections 3F and 23A2, which this court has said impose a unique obligation on the commission, and it completely failed that obligation. It failed to adequately consider whether the rule will promote competition and efficiency, and failed to explain how the rule's burdens on competition are necessary or appropriate in furtherance of the Act's purposes. And it did that in several respects. First, the commission expressly found at 384 of the Joint Appendix that the rule could improve the competitive position of dark venues relative to the exchanges, but it made no attempt to explain how this competitive impact is necessary to further the Act's purposes, which specifically include assuring fair competition between exchanges and dark venues. That's section 11A, A1C2 of the Act. The commission didn't even address that, which in itself is fatal to the rule.
What is a dark venue?
A dark venue is a trading venue that is less heavily regulated than the exchanges, and that doesn't make public quotation data. That is, exchanges, what the feed that we're talking about here provides bids and asks. Here's what you can sell and buy a share of stock at on an exchange. The dark venues attract people who don't want to have to publicize their quotes and want to trade in a more secretive fashion, which injures. The second problem that the commission didn't address in terms of competitive and efficiency impacts is, by favoring dark venues, the commission admits the rule may well shift additional order flow to dark venues, which of course undermines the purported goal of the rule to enhance information transparency in the market, because the more order flow on dark venues, the less transparency there is in the market, because the dark venues don't disclose quotation data. So again, the commission failed utterly to explain how shifting order flow to dark venues is consistent with the purpose of the Act, yet the statute expressly required it to do that.
So let me ask you, who uses these dark venues then? If I have some money I want to invest, why would I go to a dark venue when they won't disclose?
The large traders, sophisticated traders, use the dark venues because they see an advantage in not having to disclose, not letting people see what they're doing ahead of time, basically, which again undercuts the transparency.
Just so I understand the operational, they just say we have X dollars invested?
They go, so the large broker dealers, the same ones that are advantaged by the other aspects of the rule, also operate many of these dark venues. And so, I mean, I don't know exactly how they work. My client's not a dark venue, right? But you
don't know how they work. All right.
A big trader will go to the dark venue with their offers or bids rather than to the exchange, knowing that the market isn't going to see what they're doing because it's a dark venue. So they perceive an advantage in being able to trade large quantities without it being known in advance what they're trying to do.
Oh, I understand that aspect. What I don't understand is how the investor, the large investor, whatever, gets the information that they're going to make more money on a dark venue than on a non-dark venue. I understand secrecy, but you don't know how they work. So that's all right. All right. So let's hear from the commission.
Thank you, Your Honor. May it please the court. Petitioner's challenge is based on three fundamental flaws. First, petitioners mischaracterized the goal of the rule. As the commission made clear, the goal of the rule is to modernize the decades-old exclusive processor model by enhancing data content and speed and replacing it with a competitive marketplace to meet the core data needs of all market participants. Second, petitioners ignore the relevant standard. The law requires that the commission provide a rational connection between the facts found and the choice made. And here, no one denies the need for updating that outdated model. And surely there is a rational connection between replacing that guaranteed monopoly, as NICE referred to it, and that's a Joint Appendix 583, with a competitive marketplace. Third, petitioners asked this court to focus on the rule's potential impact on their profits and ignore the commission's reasonable determination based on years of study and the comments of a cross-section of market participants supporting the rule, that the benefits of deregulating this guaranteed monopoly justify the costs. Now, specifically, the commission found that the rule will foster competition in a number of areas, reduce information asymmetries between prop data users, so those are the proprietary data users, and the consolidated data subscribers that will benefit from this rule. Reduce latency for consolidated data delivery, increase market resiliency, lower data fees and transaction costs, and lead to a more informed trading decisions, better execution quality, and a narrower NBBO. You know, as this court recently recognized, the equity markets experienced a sea change in these past few decades. Exchanges are demutualized for-profit companies. This is a quote from this court's decision in the Intercontinental matter. Trading is overwhelmingly automated and electronic. Speed is key. Latency is the enemy of speed. And trading speeds today are measured in microseconds. Now, it takes 350,000 microseconds for the human eye to blink. Now, think of that. This rule addresses a market failure that is developed under the current monopoly structure. The exclusive processors, the guaranteed monopoly that petitioners control, are far inferior in content and speed to the lucrative proprietary data products that they sell. They are on both sides of this market, Your Honors. Congress was clear in its directive to the commission. It's in 11 Cap A, adopted in 1975. It authorized the commission to prescribe rules and regulations to facilitate a national market system to assure the prompt, accurate, reliable, and fair collection, processing, distribution, and publication of information with respect to quotations for and transactions and securities. And the fairness, yes.
If you could talk about innovation. So these exchanges, you know, spend money to develop certain kinds of proprietary data that obviously the commission thinks is more valuable than the core data that was initially going out. So under this rule, I mean, what incentive is there for the exchanges to develop proprietary data? I know the commission says, oh, well, we're not planning to include any new sources of proprietary data into core data, but I mean, you know, I don't know. I've seen how regulation works. I don't think it's unfair for the exchanges to assume that in a few years, whatever they develop is going to get, you know, sort of sucked into the core data category.
Well, that's an excellent question, Your Honor. I'm glad you asked it because there's a couple of things going on here that I think are an undercurrent. And one of them is that there is no competition for proprietary data products. And that is in our release. It's in our brief. This court has held in the only court decision on the merits of whether or not proprietary data feeds compete in the Net Coalition decision. And this court came to the conclusion that there is no evidence that they compete. And the reason why is simple, because the data from one exchange is unique to that exchange. You can't replicate it. There's no clear substitute for every use case. And this is based on economic data in the record, and tons of commenters agreed. So, that's one thing that we need to make clear at the outset here.
But
the idea that there's competition.
How does that affect innovation, though?
Okay, well, yes.
And I just don't, I imagine it will dampen, the creation of new forms of proprietary data.
Well, no.
Proprietary
What
data.
the commission concluded based upon its economic analysis, and that's in the appendix. There's 86 pages of Federal Register pages on economic analysis. Within that, the commission determined that the idea that the exchanges would not be able to innovate if they saw a profit-seeking or a profit-providing opportunity is contrary to economic theory. You have, they can still sell proprietary data products. They will still sell proprietary data products. They will still make money from connectivity fees, and they will still innovate in order to make faster.
But that's not addressing my question, which is that the incentives to innovate are certainly going to be dampened if they believe there is, for instance, a very small window in which they can profit from their proprietary data.
Well, another point.
The SEC just sort of scoops it into the, core data bucket.
Well, let me make this clear also, Your Honor. They have never opposed the idea of including these additional data components into core data. What they oppose is allowing competition to be the method to distribute that data. They don't want to compete on that end. And so what the commission determined was that there will be an opportunity for innovation on the consolidation side. The two biggest, or the two entities that are best situated to become competing consolidators are the exchange affiliates who run the monopoly system right now. So the idea that opening up the competition will actually depress innovation is contrary to reason. I understand their position is that they are enjoying their position in the market. They enjoy having the monopoly control at the same time that they're selling the products that don't compete with each other, and that one would need to buy every one of them. Now, not every exchange sells a proprietary data product. Some give it away for free, depending on their business model. So what we're saying is competition should dictate who are the winners and losers here, not the regulation. And that is clear. Again, from the record, from the comments, we have comments spanning the securities industry in favor of this proposal. And the only opponents to this were the ones who are both controlling the monopoly and selling the data products that people are increasingly needing because of the need for information and for speed.
Under the existing system, what is preventing competition and consolidation?
The system. It doesn't allow for competition within consolidation. The consolidated
is that because the major exchanges won't sell to somebody else, or what?
No, it's because there's an inefficiency within the market. So the way that the system was set up, and this was set up in 2005, is that there are two exclusive processor feeds that come out. They don't compete with each other because they contain different information from different exchanges. And so those are the consolidated feeds. And they also contain regulatory and administrative data that everyone needs to trade with. But their prices are set by a committee, by the equity data plans, and those prices are set for everyone. And so that's the utility type, processing system that's in place. There's no competition for that, because if you were to take that feed, you cannot. It's only the base information that's provided in it. What's provided and what people do sell, people do aggregate, the exchange's prop data feeds and sell them for a profit. But there's no competition in the exchange's setting the prices for those feeds. So they're all the exclusive processors for their own data. And if you need all of the data in order to understand what's happening in the marketplace, well, they have market power. And that's what the commission found, and that's what economists have found. And so that's why there's no competition currently in that area. And that's the market failure, Your Honor, that the commission is attempting to resolve in this rule.
Thank you. Yeah.
So let me just address one question. Petitioners will suggest that there's no one waiting in the wings to become a competing consolidator. And that's just, again, that's contrary to economic theory, but it's also contrary to the record. There were a number of commenters who stepped up in the comments and said, yes, we're ready and willing to step into the competitive marketplace. And they run the gambit. There are data vendors who are willing and ready to do this. Other exchanges are waiting in the wings to enter this market.
Is that footnote 209?
That is 2109.
2109. Okay.
Yes, in the joint appendix. So, it behooves rationality to decide that there's somehow no one would like to come in and get a cut of this $100 million marketplace that and let me tell you another thing.
Well, Mr. Frieda,
Yes.
are people waiting in the wings as we're kind of moving into through this phase-in process?
Sure.
I mean, I know that isn't directly before us, but I am curious to know if this is working the way the commission thought that it would.
Sure. Right now we're at the point where we're before the commission is the equity data plans fee proposals for the data products that would be coming from the exchanges. And so the way it works, and I wanted to make this clear because Judge Randolph had a question about this too, is that a competing consolidator will connect directly with each exchange at their data centers. And then they will be able to consolidate and send the streams to their subscribers. We're at the point where they're setting the equity data plans are setting the fees. And that's where the fee structure will come from. And so that's before the commission right now. And after that, it's only after those fees are established that the period for competing consolidators to register opens, because we understand that people want to know what the prices are that are going to be charged in the market before entering it. And so once that opens, it's open for a certain period of time in which the commission said, there should be a first mover advantage. And so it should be given incentive to those who are interested to enter the market. And then the competing consolidators will start running in parallel to the exclusive processors that are still running. And so that is where we are right now.
Thank you.
Another point, Judge Rogers, you had a question about who invests in dark pools, or who uses a dark pool to transact, to make securities transactions, equities transactions. And the answer to that is often large institutional players like mutual funds or banks. And the reason for that is part of the problem, because of the inequities of information, is that if you go to a lit market with your transaction, if you leave your liquidity, if you leave your orders there, they can get picked off by people with faster access to faster information. And so these what they call them dark pools. The reason, I know it sounds like it's sinister, but it's not. It just means that you don't have to show your liquidity on the market. You can interact, and you are guaranteed to get at least the best going price if it's transacted on the dark pool. They're called alternative trading systems, and they're run by large broker dealers and so on. It's just one aspect of the market in which we actually, frankly, have very robust competition for transaction services. As counsel mentioned, there's like 15 exchanges, dozens of alternative trading systems. And so that end of the market is very, very competitive. It's the data processing and providing. It's the idea of a consolidated feed that Congress envisioned in 1975 that everyone agrees is lagging at this point. And really the only question before the court is how do you best address that? And that's what this rule does. The rule takes the data components that no one disagrees with being helpful to the market, being the information that that market participants increasingly need in order to compete. The only question is how can we deliver that? And the commission decided that creating a competitive marketplace, consistent with our values for hundreds of years, would be the most appropriate way to go about doing this.
Thank you. Any further questions? Judges?
No. Thank you.
All right, thank you, counsel. All right, does counsel for petitioners have any time left?
Council have 1 minute and 30 seconds.
All right, I'll give you 2 minutes, counsel.
Thank you, Your Honor. A few brief points. First of all, counsel for the SEC claims for the first time today that reducing information asymmetries was not a goal of the rule. That's plainly false. We've cited numerous provisions in our brief. I'll just point the court to JA 219, where the court says that this rule will address the concerns about and improve the content and latency differentials that currently exist. It's unquestionably a claimed benefit of the rule, and when their claimed benefit is actually a detriment, that renders the rule arbitrary and capricious. Counsel claims that exchange proprietary feeds are faster than the SIPs, the consolidated feed, and that this is due to alleged failure to innovate. In fact, as we noted in our brief, and it's undisputed, the aggregation speed, which is in the control of the SIPs, is less than 20 millionths of a second. The reason consolidated feeds are slower than proprietary feeds is because they have to be aggregated. And that means you have to wait for the data to arrive from multiple different exchanges in multiple different locations. And there is inherent geographic latency when you're sending data over fiber or even microwaves from miles away. And so the consolidated feeds will always be slower than the direct feeds. That's an inevitable consequence of geography, not a consequence of alleged failures to innovate. It will be true in the new system as well. Innovation will indeed be hindered, as we've shown in our brief, and the Commission utterly failed to address that concern. They say, oh, well, the exchanges will have no reason not to try and innovate because they can try to make money in what little is left of proprietary data. But the fact is, now that their attempts to do that have been confiscated, the bait and switch is going to render them unwilling to do it again. And plus, they will have dramatically reduced funding. And the Commission utterly failed to consider the economic impact and adverse consequences of the elimination of this incentive to innovate.
Mr. Hunter, Mr. Frida's main position seems to be that the petitioners here are just, unhappy that they're losing their monopoly position. I mean, what is your response to that?
Two responses. Number one, he also said that there's no evidence, and the Commission denies that exchanges compete in proprietary data. That is completely untrue. The Commission says at page 227, it talks about the ways in which it envisions the competing consolidators are going to compete, including on latency. And then it says, competing consolidators will likely compete along all of these lines, similar to the manner in which the providers of proprietary data products have competed. That's 227 in the Joint Appendix. They do compete right now. It's not that competition is the problem. It's not that even competition with competing consolidators is the problem. Indeed, the exchanges at various points have proposed competing competition models for consolidated data. The problem is the manner in which the Commission has implemented it, and the fact that the Commission's proffered justification completely undercuts what they've done, because they're making the problem that they claim to be addressing worse. Unless the court has any further questions, we ask that the rule be vacated as arbitrary, capricious, and contrary to law.
Thank you, counsel. Will take the case under advisement.
This honorable court is now adjourned until Monday, March 21st at 9:30 a.m.